Fair.
Scott's a good guy. So.
Let me tell you a little bit about Scott. So I'll tell you a little bit that I know about Scott. First of all, Scott is unflappable. I don't know if inside when like the storm is just raging, if Scott's maybe nervous or anxious, but outside, he just calmly responds to any sort of craziness. And maybe that means he just moves, but he's unflappable, and he's really able to take difficult and hard situations and not let that affect him, and just respond in a very courteous and civil and professional manner, and make smart and wise decisions without letting all the maybe contention or anything around him affect him. Also, in terms of professional, so Scott works for the enemy. He works for a great firm called Miller Harrison, and he has far-reaching experience in property law with an extended knowledge and understanding of community association law and builder-developer law. He's licensed in Arizona and Utah, where his primary practice focuses on residential real estate developments, including representation of community associations, home builders, and real estate developers, offering general counsel, litigation, drafting and interpretation of governing documents, negotiation of contracts and other legal documents, and covenant enforcement. He also practices in collections and general real estate, where his experience includes quieting title, resolving boundary disputes, and drafting and defending easements. He's a member of the board for the Salt Lake Home Builders Association and the Utah Community Association Institute's Legislative Action Committee, a body that drafts and advocates for community association legislation. Prior to practicing law, Scott worked in the offices of a major developer in the Phoenix metropolitan area and at the Arizona State Legislature. After 4 years of practicing law in Arizona, he and his wife moved to Lehi, where all 3 of their children were born. Scott loves the mountains and the fly fishing that Utah offers, but will never stop being a fan of Arizona sports teams, no matter how many times they break his heart. Scott, we'll turn the time over to you.
Okay, thank you. I'll echo Bruce. Jeremy probably said more nice things than me than are warranted, but I appreciate it. I will say, Jeremy mentioned I work for a firm called Miller Harrison. One of the things that I love about practicing in the world of kind of HOA law is that it's a fairly small community among the attorneys, and have great respect for the firm that Bruce has built up, that Bruce and Jeremy work at. And there's really a handful of firms who this is their where they spend the majority of their time in their practice, and it's a great community, and it's great to be a part of it. Before I came here, and I'm going to do what Jeremy did and give a little bit of background, because I think it's relevant to kind of my perspective on some of this. Before I was working for Miller Harrison, I worked for a firm called Weil Fotheringham, who gained some reputation in Utah because they brought some of the major construction defect cases, especially early on in the kind of construction defect, the building and developing of construction defect law in Utah, and really kind of helped to shape that. And so my practice was in that firm, and became really familiar with and worked on some of those construction defect cases, and gave me kind of a perspective I wouldn't have had otherwise that I think was valuable. And Miller Harrison, on the other hand, a number of the attorneys there had previously worked for Weil Fotheringham, and part of the thing that kind of, I guess, caused them to switch firms, and we all have great respect for Weil Fotheringham, and there's great attorneys there that I love. But part of what kind of drew all of us away from it is that we started to build relationships with builders and developers, and began doing work for them, which just didn't fit the mold quite as much. So I bring that up to say that I do a lot of HOA law, but I also do a lot of work for builders and developers, and that kind of shapes my perspective on HOA law. And a lot of that is HOA related, helping them with their kind of covenant issues and building building those communities, the legal framework for those communities as they're developing. So part of what I'm going to talk about today is going to include kind of the general HOA side, but I'd like to mention and talk about how does this apply to developers and what's unique with developers on these issues. So let me get to my slideshow here. I'll share my screen. Oops. Okay. I'm not sure what's going to happen when I do the slideshow view. Okay, I think that worked. So I'm going to talk about HOA boards um, and dive into kind of that specific aspect of HOA law. This picture here, I think, actually, this picture sums up HOA disputes in a lot of great ways. You have the kind of assertion of property rights, uh, some aesthetic issues, which HOAs just love to, enforce their aesthetic restrictions, some landscaping issues. And I think that, and I fear actually a little bit that when somebody thinks about HOA law, they think kind of this is what it's about, right? It's about sticking it to the neighbor. It's about the petty disputes that honestly, frankly, it is true that there are petty disputes that you deal with when you're representing HOAs in a legal capacity. You do have to sometimes get involved in some of these kind of silly disputes over the color of that somebody painted their door or whatever. There is some of that, and I fear more that boards view their role as this sometimes as this kind of police of these petty issues. Here's another slide that I think kind of demonstrates that. I think that some people think of this is the typical HOA board president, right? And this is his role to go around and say how tall is your grass. And when I was going to law school, I went to this law school in Tucson and U of A, University of Arizona. My third year, I wasn't married. I moved into a home with a group of other guys, and we were renting a home in a neighborhood. It was my first time living in an HOA. I grew up in a small town. I didn't live in an HOA there. So this is my first time living in an HOA. And we would, about once a month, we would get notes. We happened to live across the street from the HOA board president, and we would get notes from her about the silliest things. Often it was that the leaves on our trees were on our driveway and we needed to sweep them off or whatever. And so it gave me kind of an initial really bad taste in my mouth of what an HOA does. And unfortunately, I think that is a lot of people's experience and how they think of HOAs and HOA disputes and HOA boards. And again, there is some truth to that. There is some pettiness. There's certainly some pettiness that goes on between neighbors, between boards and the rest of the community that the HOA attorney sometimes gets dragged in on. But I think that it's really important as a legal community and as a real estate community generally to kind of keep a bigger view and recognize that as Jeremy and Bruce have really done a great job of starting to show that it's much more an HOA and an HOA board is much more significant than and should rise above the petty things because there's real significant case law and legal principles and statutes that apply to boards that from an attorney's perspective, the board is much more than a kind of group policing the neighborhood for landscaping issues and that sort of thing. But what they actually are is a corporate board, and like any corporate board, and Jeremy showed this well. The Nonprofit Corporation Act applies to them. Now, again, as Jeremy showed, that's not necessarily the case for every homeowners association, but I agree with him that it should be. I encourage all the HOAs that I represent to incorporate as a nonprofit corporation if they're not already. There's not a requirement to be incorporated under either act, to be incorporated as a nonprofit corporation under either act. But if you're going to register as a business entity, which you should, one, because the non-condominium act says that you need to be a business entity. And of course, as we know, for all the liability protections that come with being established as a business entity, if you're going to do it anyway, then might as well do the Nonprofit Corporation Act, which is going to have some tax benefits, but also has a lot of benefits for HOAs because it kind of works hand in hand with both of the acts that govern community associations and condominium associations. So, so let's start off with the most basic question first, and that is a board even necessary? If you live in a community association, if you're working with a community association, if you're developing a community association, is there even a need to have a board? And I've had this question from time to time. I've had some communities, usually smaller communities, push back and say, do we even need to have a board? What's the point of having a board if there's 5 units in our community and we just kind of make decisions together? Or even sometimes larger associations kind of have that same perspective of, we don't want a central body. We just kind of want to be a kumbaya community as much as possible and make decisions together. Well, under the law, there is a requirement to have a board. Again, if you're incorporated under the Nonprofit Act, then the Nonprofit Act says that a community association shall have a board of directors. And often we see in statutes that apply to community associations, there's often a provision that'll say, unless otherwise stated in your bylaws or unless otherwise provided in your articles of incorporation. This is not one of those provisions. Nonprofit corporations have to have a board, and so that applies to HOAs who are nonprofit corporations. In addition to that, the Community Association Act, which again, this is the non-condominium act, also says that upon termination of the period of administrative control, so once the developer is no longer the entity that's controlling the community, which that's going to be a very specific time frame. Your governing documents will say, how long does the developer control this community? What's kind of the trigger for them to no longer control? The acts, the Community Association Act, the Condo Act have something to say on that topic as well. But once that period is officially ended, at that point, the Community Association Act dictates that the lot owners shall elect a board. So those two acts say that you have to have a board. The Condominium Act actually doesn't specify that you have to have a board, but several of the provisions in it assume that you have a board. And so I think it's implied in there that you should have a board. And they refer to it as a management committee, but I think it's implied there. And I think it'd be difficult to comply really with all of the Condominium Ownership Act if you didn't. And again, if you're a condo association that's incorporated as a nonprofit corporation, then by the Nonprofit Act, you do have to have a board. So yes, there is a requirement to have a board. And that becomes significant for some other reasons that I'll get into shortly. But there is a unique situation though. I showed that the non-condominium act, as I call it, the Community Association Act, it only says you have to elect a board after the period of declarant control. And there's also a provision in the Nonprofit Act that kind of gets you out of having to have a board in every circumstance. And this especially can be useful for developers. So it's up here, 166A-801. It says that a nonprofit's articles of incorporation may authorize one or more persons to exercise some or all of the powers that would otherwise be exercised by the board of directors. And then goes on to say, if an HOA exercises this option to any degree, the director shall be relieved to that extent from such authority and duty. So in other words, you can, in your articles of incorporation, and that's something to note here, this isn't an automatic authority. It has to be stated in your articles of incorporation, or else you don't have the right to do this. But if your articles of incorporation allow you to, then you can delegate some or even all of the board authority to, and the law says a person, and of course then it goes on, if you look at the definition of what a person is under the Nonprofit Corporation Act, a person includes an entity. So you can say, well, we don't have a board, but we have officially delegated the board authority to this individual or to this entity. There's this practice that I think is just kind of something that's probably developed by habit over time of developers appointing boards and saying officially, here's who our board is, here's who the specific people are who serve on that board. And that's not necessary. And in fact, I think you can save some headaches. There's a potential of liability, and it's a realistic potential, because sometimes when construction defect claims are brought against the developer, not only are they going to name the developer, but they're going to name the individuals who are appointed to that board and say you're liable because you breached fiduciary duties and other things. You can help developers kind of escape that by not appointing a board, but instead delegating those powers, those authorities to an LLC, maybe to the declarant LLC or to some other LLC, or to one individual if they wanted to go that route. That is a provision that's available. It can be taken advantage of. But keep in mind that the Community Association Act says after the period of declarant control, you have to elect a board. So there is this kind of hierarchy statute in the Community Association Act that says if there's a conflict between this act and the Nonprofit Act, then the Community Association Act prevails. So you do kind of have a conflict there where you have one act saying you got to elect a board, another act saying you can delegate all the authority to a non-board. Since there is that conflict, we know that the Community Association Act prevails. I would say that you do have to elect a board. You cannot delegate the authority to another party or another entity, another person, after the period of declarant control in a community, in a non-condominium association. Could you do that in a condominium association? That's probably something that attorneys could sit around and nerd out on and have some different views on, but it's not as clear under the Condominium Act that you have to have a board. Maybe you could delegate it to someone else. Which gets me to the next point. So what does your board have to look like? I used to work with an attorney, Ted McBride, who loved to use this picture of this king in presentations to boards, and he would he'd often have a caption on it that said something like, "I'm the king, now what?" Because sometimes that's attitude that we see lead to legal problems. In a condominium association, can you have one individual has all the power delegated to them? I ask that because I've seen this happen, and probably other attorneys listening or on panel have seen this happen as well. It seems to be especially in condominium associations, where you have one person who comes in and they start to buy up a bunch of units, and it's of course deliberate. They're thinking, I'm going to make this place my investment, and if I buy enough units, then I control the vote, and I essentially control the project. And then it becomes almost more like a hotel, at least kind of from their business perspective. Well, the tricky thing there, though, is you have one person who controls the membership vote, but what about the board? If there is a requirement for them to have a board, can they establish themselves as the board and make the decisions, or do they still have to surround themselves with other board members and really still run their decisions through the rest of the board members and have a vote from everyone else? Well, the Community Association Act takes care of this issue by saying that in non-condominium associations, your board has to have at least 3 people, so you can't have a one-man board. The Nonprofit Act also says that. So once again, if you're incorporated under the Nonprofit Act, then that question is answered. If you're a condominium association that is, maybe you're set up as an LLC, I've seen that a few times. Maybe you're not incorporated at all. Can you then escape that and then have a one-person board? Possibly. I had one client who, one condominium association client who had this situation one person owned like 75% of the units and was kind of controlling the decisions. I explained this issue to him and kind of the problem. And his solution was, well, then I'm going to make everybody a member of the board, and amended the governing documents to say that anybody who owns a unit is a member of the board, and that your vote on the board, and maybe somebody on the panel will correct me if I'm wrong. I'm not aware of any provision in the Condominium Association Act that says that board members have to have an equal vote. And um, so his solution was to say, well, your vote on the board is equal to your vote as a member, and then essentially he controls the community that way. So that's just an interesting approach and interesting issue that you do sometimes face. We do often see these kind of king of the community type issues, and what I think it ignores and runs contrary to is that you have to have, in most instances, the Nonprofit Act is going to require that you have a 3-person board. And so even though you own most of the units, things that the board decides on still have to be decided on by a board. Okay, so what does the board do then? It kind of begs that question. And again, this is a very common issue that we usually hear it from members of the community who don't like what the board is doing. And often when you get in those situations where there's some kind of dispute or somebody upset about decisions the board is making, and sometimes just the community attitude in general is, we don't want a central body that is telling us what to do. This is my property, right? You can't tell me what to do on my property. And so we would rather have the members be informed as often as possible on any issue that comes before the association. And now sometimes, always, I would say this is very impractical, because I think it overlooks the fact that there's a lot of kind of day-to-day decisions that need to be made on little things that you're not going to gather everybody together to make a decision on, whether your landscaper can charge you 10% more this year than last year, or whatever. But it's not an uncommon complaint to hear, or sentiment that this is how we want to run our community. Everybody comes together, everybody has a say in any decision that's made, and shouldn't we have a voice on that? It's my property, after all. Or kind of a variation of that is, well, the board made this decision, we're aware of that, but we as the members disagree with it, and we have voted, or we've signed our name to a petition or whatever else, and we don't like that decision, and so we're saying that this instead should be the decision. And what often comes as a surprise to the members is you don't actually have authority to do that in most instances. What both the Condo Act and the Community Association Act make clear is that, and I've put the language of both of them up here, and they're very similar to one another. Couple of small variations, but basically what they say that except as limited by the CCNRs, essentially by the governing documents of the HOA, except as limited by those documents or by the law, by the Community Association Act or the Condo Act, except as such limited, the board acts in all instances on behalf of the association. So I think the question usually when a board has a problem arise and they're saying, how do I deal with this problem? Do we even have authority to act in this instance? Because there's things where the boards are usually comfortable. They know that they have authority to send somebody to collections if they're not paying their assessments, or enforce a specific provision the CCNR is about architectural guidelines or whatever else. But it's when things come up that are kind of not so obvious, not clearly covered in the governing documents, not clearly covered in the law, where you get this question of boards sometimes get nervous, members sometimes get frustrated. Does the board really have authority to act in this situation? My take from the language in both the Condo Act and the Non-Condo Act is that the more appropriate question really is not where can I find specific language authorizing me to act in this situation if I'm a board, But instead, is there specific language saying I cannot act in this situation? Because that's really what both of these provisions say they're a catch-all, right? There's a catch-all provision that says unless you're specifically limited from acting as a board, rather by either by the HOA's governing documents or by statutory law, unless either of those things limit you, then you are the body that is authorized to act in all instances on behalf of the association. Now, what that also means, kind of by reverse, is that the members are not the body authorized to act in all other instances on behalf of the association. So if the members want to get together and say, you know, we want to adopt a rule about speed limit in the community, and the members all vote on it, but the board never officially adopts that rule, then there's no authority. There's no provision of either of the acts that say that there's authority for the members to do that. Or to make decisions about who to hire for landscaping or those sorts of things. All of those things are kind of fall into this catch-all provision. So what are those things? And I believe I have a slide on this. Nope, I don't. Let me just kind of give you off the top of my head a rundown of commonly the things that are commonly delegated to the members. And most of these aren't required under the law, but very common. It's very common for the members to have some kind of authority over special assessments. Sometimes your governing documents will say any special assessments has to have approval from the members, and whether that be a majority or a supermajority of the members. Sometimes the documents will say special assessments above a certain threshold, over $5,000 a unit or something like that, has to have approval from the members. That's a common one that's delegated to the members. Amendment to the governing, I say the governing documents, but more specifically, amendments to the CCNRs especially are almost always delegated to the members. You have to have usually a supermajority to amend the governing documents. Election of the board is delegated to the members, right? The board can't just reappoint board members into infinity. So those things are usually delegated to the members. LUDMA, the Land Use Development Management Act, which has a few provisions in it that apply to HOAs, and that's kind of one of the other statutes that we sometimes need to look to regarding HOA issues. LUDMA has a provision that says that an HOA cannot alter the size or the place of its or location of its common area without a vote from 67% of the members. So where that usually becomes most applicable is the HOA gets an offer for the city or somebody else to buy some land, some of its common area, or they want to sell some of it. They want to relocate an amenity. And so that's another one of those instances where there is specifically under the law a requirement that the members have a say in that. So again, other than those few specific things, though, that are either in the law or in the governing documents, then what the acts say is that otherwise the board is the authorized body to act on behalf of the association. Okay, so if they're acting, then what are the parameters of that? So let's talk about fiduciary duties. And Jeremy touched on this some. And again, this really is a very useful talk to have with community associations, in helping them recognize that it's more than just kind of this grassroots group of people who are going to now sort of police what the community looks like and cover those little things. There are very significant, serious duties under the law that we have well-established case law regarding, and we have some statutes that we can look to that dictate what are their responsibilities, what's the board's responsibilities to the community. First of all, what's a fiduciary? So simple explanation, a fiduciary is somebody who's managing or controlling property or power for the benefit of another, which of course applies to an HOA board, because one of their primary functions is to kind of manage the property, the actual real estate of the HOA, if they have green space or whatever else that's common area, but also to manage the money of the members. They're paying dues, and the HOA board is the one that's kind of managing that money. So they're a fiduciary in that sense. They're managing somebody else's or another entity's property. And as is kind of easy to imagine, the law has something to say about that, that if you are managing somebody else's property, they're trusting you with their property, then you're going to have some duties. You can't just kind of spend somebody else's money, you know, willy nilly or whatever else. You're gonna owe some legal duties to that person or to that entity, and so that's kind of in a nutshell what fiduciary duties are. You know, what kind of obligations do you owe if you are kind of in control of somebody else's property um and their money. So I think this one was shown by Jeremy. This is under the Nonprofit Act, and it's where we've codified, where Utah has codified what the fiduciary duties of a community association, not just community association board, but any nonprofit board, what their fiduciary obligations are. So I've broken it up into three parts. First, the statute tells us what the standard of conduct is for those board members, and that's a board member is obligated to discharge his or her duties in good faith. The statute, I don't have it up here, but the statute goes on to clarify that what good faith means in this context is that if you know something, if you have specific information that something you do would not be in the best interest of the association, and you do it anyway, then you're not acting in good faith. So basically, good faith in this context means that you are acting actually according to the knowledge. You're acting according to the knowledge that you actually have regarding the decision being made. There's an obligation to act with the care an ordinarily prudent person in like position would exercise under similar circumstances. So here, for attorneys who are listening, you know, that's kind of similar to a tort, kind of a negligence type standard, kind of a reasonable care, similar to a reasonable care type standard. You are, as a board member, are judged against what an ordinarily prudent person in a like position would do. In your situation, what would another board member do if they were an ordinarily prudent person? You know, kind of the reasonable person standard. And the third one is you're required to act in a manner the director or officer reasonably believes to be in the best interest of the nonprofit corporation. So this one is actually a subjective belief standard. What did you actually believe that was in the best interest of the corporation? But not only did you believe it, was that belief reasonable? Did you reasonably believe that what you were doing was in the best interest of the HOA? That's the standard. There's a couple of things that kind of help relieve boards if they might make mistakes, which they will, because all of us do. You can rely on third parties, and that's specific under the statute. And basically what this says is that when you're undertaking your fiduciary duties as a board member, you're entitled to rely on others, but it specifies who those others are. So you can rely on agents of the HOA that you reasonably believe, you know, there's another reasonable belief standard, that you reasonably believe to be reliable and competent in the matters presented. Notice that one doesn't say it has to be a professional, you know, it doesn't have to be some kind of licensed professional or whatever else, but you do have to have good reason. You have to reasonably believe that they're reliable. So maybe you have a member in the community who has, you know, some engineering experience or something else. And if their experience, you know, was extensive enough that it wasn't ridiculous to rely on what they had to say about, you know, what the HOA does with the remodel on its clubhouse or whatever else, then the HOA is entitled to rely on them. And then the next group of people that the statute says you can rely on: attorneys, CPAs, other persons the board member reasonably believes to have expertise or competence in a matter. And then the last one is HOA committees. And this one is actually a lower standard. It says that the board member has to reasonably believe that the committee merits confidence. In my opinion, that's a lower standard, that the committee merits confidence. And so where I see that playing out is you have a committee that the board has said, hey, we got this issue, we're not sure how to handle it, and you know, it's creating a problem for the community. We're gonna create a committee to go research the issue and research what a good solution is. If the committee acted responsibly, if they, you know, if their research was was thorough, and the board kind of sees what they did and says, yeah, we think that the process you followed was good. We're going to rely on your recommendations. Then the law says they're entitled to do that. So what does that mean? What does it mean that you're entitled to rely on this kind of information or data presented and other things from a third party? Well, what it could mean is that it relieves you of some liability. And I tell this to boards all the time. If you have complicated questions facing you, one of the best things you could do to protect you as a board and the HOA from liability is consult with others who are experts on those issues because of this specific provision in our law. Because what that means is that if they go and talk to an attorney, which I've heard sometimes give bad advice, I've not experienced that myself. I'm joking, but if they go talk to an attorney and that attorney comes back and tells them something that is just plain wrong, but the board had no good reason to know that the attorney was wrong. If they said, well, this is an attorney that we've, don't have any good cause to believe that he gives bad advice, maybe they even looked up his bar record and say, there's no complaints against him or whatever else. And, on appearance, it looks like it's a competent attorney, but they get advice from him that's just plain wrong. And the board takes that advice. And as a result, that something bad happens to the community and they end up in maybe they get a judgment against them or something else that ends up costing the community a lot of money. Well, what this is telling us is the board was entitled to rely on that attorney. And by relying on them, then I think the implication is that the law is not going to hold them responsible for that kind of bad result because they relied on somebody that they had good reason to think was competent. I like to say that when making decisions, it really is less about the end result of that decision. When we're talking about is a board going to be liable for a bad decision, it's less about how that decision played out, and it's more about how they arrived at that decision. And I think that's kind of the thrust of our law, is that if you follow the right process, even if the result is bad, even if the decision turns out to be the wrong one, if you followed a good process in getting to that decision, then the likelihood of liability is low. And that's emphasized by this third point, which is even more of a kind of get out of jail free card for a board, which not only, if you want to hold a board liable for a decision they made, not only do you have to show that they breached their fiduciary duties, but you actually have to go a step further. And the law says that a board is only going to be liable for the breaches that were the result of willful misconduct, intentional infliction of harm on the HOA or its members, or gross negligence. So that's a very high standard. In my experience, and I would love to hear from others, I kind of asked around the office while I was preparing this because I just kind of got this question in my mind that I became interested in. I would say in my experience, I've seen a lot of lawsuits against HOA boards that allege breaches of fiduciary duties. I can't think of one, and I could just not be remembering correctly. I can't think of one where the judgment ended up specifically being based on that breach of fiduciary duty was proven. Often what happens is that there's other allegations that are easier, that are not as high of a standard as having to show willful misconduct, intentional infliction, gross negligence, etc. A lot of times that if somebody has a complaint against an HOA and against a board, they're going to include an allegation, cause of action for breach of contract or breach of the governing documents. That I think can be easier to prove. I mean, in several circumstances, because if you can show here's what the CCNR said to do and you didn't do it, that's a breach of contract, and that's not as high of a standard of saying, we got to show that you actually did that willfully. So at least in my experience, a lot of times these cases resolve on those issues, and I think that this is the reason, because actually prevailing on a breach of fiduciary duties claim is a high standard. Now, I don't have a slide for this, but listening to Jeremy talking about the business judgment rule kind of did bring another and I think it's related here, to bring another thought to my mind. So, this kind of codifies the business judgment rule. It's codified further in portions of the Community Association Act and the Condominium Act. One of the questions and issues that often arise as well, and this does relate to my next slide. So my experiences is my very kind of non-scientific uh, list of common lawsuits faced by boards of directors. A lot of the allegations that I've seen over the years, failure to maintain and repair common property, failure to adequately fund reserves, improper budget management, failure to collect assessments, negligent hiring, supervision, selective enforcement, or non-enforcement of governing documents. All of these things can be tied back to fiduciary duties claim. You could say, well, this isn't what, this doesn't meet that kind of standard of conduct that we talked about. If you didn't properly collect assessments, a prudent board member would have properly collected assessments, and now maybe they can show damages because now you don't have enough money to fix our driveway or whatever, that our common driveway, that's reducing property values or whatever. You can think of, there's ways to tie damages to these types of claims. That last one on there, though, that selective enforcement is one that we hear a lot. And this is where there is some codification of what to do in these situations. How do you analyze whether a board has breached its fiduciary duties if they have failed to enforce in every instance against some kind of violation? And so it's a very common claim from members of the community that you go after them for some kind of issue. Your garbage bin has been out on the curb for 5 days, and you're supposed to bring it in after 2 or whatever. Very common retort that they say, well, that's selective enforcement because so and so down the street, I don't think you ever enforce against them for that issue. Now, to me, the more concerning claim there is if they can tie that to a fair housing issue. Because if you say, well, you're selectively enforcing against me, oh, and by the way, I'm a member of a protected class, then I think we have an allegation that should make the board nervous and that they should really look at carefully. But if they're just kind of generally saying, they're not claiming they're a member of a protected class, and they're just kind of generally saying, I think you've enforced against me selectively, in my opinion, it's hard to get real far with that claim for a few reasons. One is because, there's kind of a damages issue. I think that ironically, maybe the HOA, maybe members of the HOA have a better claim for all the times they didn't enforce rather than the 1 or 2 times they did enforce, because maybe all those times they didn't enforce, that created damages of property value issues or whatever else. But the other issue is that we do have these sections in the Condo Act and in the non-Condo Act that give some guidance that say that under certain circumstances, a board is authorized to decide that it's not best to enforce. And the law kind of specifies what those circumstances are. They have to be acting in good faith and without conflict of interest, and have to have fair review of the situation. And then basically what it boils down to is there's this list of factors that are kind of hardship type factors, or the association saying, it's not worth our time and money because we think we might get into a legal dispute over this or whatever else. But basically the law says there are situations where the board doesn't have to enforce strictly. And to me, that again is really just kind of an expression of one aspect of the business judgment rule, that boards can make those decisions, and a court isn't going to come in and substitute their judgment for the board's judgment if they think that maybe we don't enforce in every instance. What's interesting about that is Jeremy mentioned the first breach doctrine. If you have a contract and you're the first one to breach that contract, then the other party can raise that as a defense and say, hey, you breached the contract, so I didn't have to fulfill my end. Well, this specific provision of the law gets around that, or at least attempts to get around that, by saying, if a board decides not to enforce in these circumstances, that's not a waiver of their right to enforce, which isn't directly addressing kind of this first breach issue, but I think it sort of is. Basically saying that this doesn't breach their obligations, or at least it doesn't kind of negate the covenant generally. Okay, so I mentioned that there are some unique things for developers, and this is one of the issues that is really a hot topic for developers, or a kind of a touch point for some real liability, for real potential for liability for developers, and that is, what are their fiduciary duties for the time that they are running a community? If you're not familiar with how this kind of usually plays out, when a developer develops a community, at first, they're going to start selling off units or homes, and they're going to get to this point in time where some of the units are owned by third parties, by others that have bought those units, and some of the units are owned by the developer, and they're still trying to sell more units, and they don't want to be in the position where they lose the authority, the ability to kind of dictate what the covenants are, what the community looks like, what the assessments are, because they're still very interested in having a community that's marketable for those that they're trying to sell to. And so because of that, practices and laws have developed to basically say, a developer controls the community for a certain period of time. What that timing is depends on your governing documents. And the Condo Act, it's very clear, has some very strict provisions about when the developer has to turn over the community based on kind of some different factors. But there's always going to be some period of time when the developer is controlling the community. And as long as they're controlling the community, whether they're doing that by kind of delegating to themselves or their entity or whatever else the authority of the board, or whether they're appointing a specific board, the law recognizes that they effectively are the board. They are the body running the community, and because of that, they're going to have some duties. But what the law also recognizes is that it's different than a board that's been elected by the members. They just inherently have different interests, not entirely different interests, but some interests are different. The members electing a board after developer control is finished aren't going to be so concerned about how marketable the homes are. I mean, yeah, they're concerned, I guess, about their own property values, et cetera, but it's not as much of a concern. A member-run board is going to be more concerned about just the comfortable place it is for them and their neighbors to live in. The developer has these business interests that are a little bit different than any other owner, and the law recognizes that and accommodates it. So there was a case that was a landmark case in Utah, 2009, Davenport at Pilgrim's Landing, Homeowner Association versus Davenport. Davenport v. Davenport is kind of the short of it. Davenport at Pilgrim's Landing LC. So this was a homeowners association who brought a construction defect claim against the developer of this townhome community in Lehigh, where I live. And I don't live in Davenport, but I live in Lehigh. And when the case went to the Supreme Court dealt with the defects, the physical structure claims separately, but then they also said, in addition to whatever liability that a developer has for those kind of standard defect type issues, they also have some liability for how they've run the community. And so then the court was kind of forced, since that was one of the questions of what kind of liability does exist for how a developer runs a community, the court was forced to grapple with this question of, well, what exactly are a developer's duties that they owe to a community, from kind of through this lens of sort of HOA board roles. And they specifically acknowledge, like I said, that it's not going to be the exact same as it is for a member-run board, but they then went on to list, borrowing from the restatement, they listed the duties that a developer does owe to the community. I won't read through all of them, but But one of the big ones I will say is establishing a sound fiscal basis for a community, and that's one that developers historically have got dinged on over time when they've been sued on these issues. You know, a homeowners association will often say, not only did you build a bad product that is making this place uninhabitable, but you also left us with reserves or accounts that don't have enough money for us to address all these issues that need to be addressed. And that is a viable claim in Utah because the law says specifically that when a developer is running an HOA, they have a fiduciary duty to the HOA that upon turnover, they're going to turn over a community that has a sound fiscal basis. And there's some other things. Disclosure. I'll tell you right now, I represent some developers, and I am personally seeing quite a few soils claims coming up. When I say claims, I don't mean lawsuits necessarily, but a lot of we hear homeowners saying they're seeing, and when I say soils, I mean some settlement issues. I from in my practice, from my viewpoint, I'm seeing more of those over the last handful of months, and that's seen for a while. And one of the issues that kind of highlights for a developer is if you're selling these homes and you know that other owners have complained about some indications of settlement and shifting foundations or whatever else, then at least one of the obligations you have is to disclose that, because that's one of your obligations. And of course, just as a seller in general, it's an obligation. But under Davenport, you have some obligations to disclose these kind of material conditions about the property that are going to be important to an HOA upon turnover. So, and there's others, and you can go back and look at this and see kind of what this list is, or just look up the Davenport case, and it spells out clearly what those fiduciary duties are. Okay, so let's move on now to the next thing, board meetings. And this right here is not what a HOA board meeting should look like. And a lot of times when we get frustrated, when homeowners on the line, it's because they feel like this is what an HOA board meeting is, right? A group of board members kind of huddled together and being very secretive about the things they're discussing, and not a lot of opportunity for members to kind of be in on those meetings or aware of what's being discussed, etc. Well, let's dive into that quickly. First of all, it's important to define what a meeting is under our law, which maybe sounds like an obvious thing, but there are some important things in the way that our law defines a meeting that kind of play out into then how you have to conduct those meetings, and when are you actually considered to be having a meeting, and when are you just sort of maybe talking as a couple board members. So meeting's a gathering of a board. That word's going to become important in a second, and it's whether by person or by means of electronic communication. That phrase is important, and I'll explain why. At which the board can take binding action. So if you don't have a quorum there and binding action can't be taken, then the board can meet without really any worry about the legal requirements for an actual meeting. Because if binding action can't be taken, then it's not actually what the law considers a meeting. We have an open meetings provision in Utah law that looks kind of like, I think it's comparable to what the municipality open meeting provisions are. It's not the exact same by any means, but it's kind of a similar idea. Basically, what the open meetings provision says is that before a meeting, and that's where that definition, what is actually a meeting, becomes important. Before an actual meeting is held, a 48-hour notice has to be sent out to the community, but only to the owners who have actually requested notice of meetings. At a meeting, homeowners have to be given a reasonable opportunity to offer comments. There are statutory penalties if a board doesn't comply with the open meetings provision, and there's an exception for developers. Developers don't have to follow this process for every meeting. They do have to have one meeting a year, though, where it does follow the open meeting provisions. And then there's an exception, though, for closed session. And a board can go into closed session for a handful of things if they want to consult with their attorney, for instance. There's kind of a catch-all, discuss a sensitive or private matter, so there's, I think that these exceptions are actually fairly broad. The language is pretty broad. But a board can go into closed session for these things. But what you'll notice if you read through what the exceptions are, it's all consult, discuss, 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 discuss. None of it is pass, vote on, etc. So a careful reading of this provision tells you that a board does not have legal authority to make decisions, or at least to vote on decisions in a closed session, but they can kind of discuss the issue, come to a decision, or at least, kind of arrive at their opinions, and then in an open session vote on the matter. Now, practically, you might go, well, how are you going to vote on the matter without disclosing some of these things? But you can do that by just sort of saying, hey, we're going to vote on member A, refer to them by member A or X or one or two or whatever that we talked about, or matter one or two or whatever. But the vote actually has to take place outside of the open session. And then the last one, last thing that I'll touch on is there is this whole area, or these provisions under our law that allow a board to take action even without a meeting. So you have to have open meetings, but you can take action without formally having a meeting. And again, that's where this definition of what a meeting is becomes important. If a board is emailing back and forth and wants to make a decision over email, is that a meeting? No, I think that the common consensus is no. One of the phrases that I pointed out in the definition of a meeting is that a meeting happens by a meeting can be something that takes place by means of electronic communication. I think that's the terminology they use. But there's actually a definition for what that is, and what the law says is that, well, that's electronic means where the communication is taking place in real time. And so email, doesn't take place in real time. I suppose you could argue that if you're all sitting at your computers responding to your emails right away, maybe that's real time. But I think the general consensus is email is not real-time communication. And in fact, our law specifically references emails in some of these relevant provisions. So if a board wants to make decisions over email, that's considered taking action without a meeting, and it's specifically authorized under our law. And basically, what the law says is that there's a certain process you have to follow. And what that process is that a board member or somebody sends out a notice of what the issue is that needs to be voted on. They are required to say the deadline for casting your vote or speaking up over email. They give that deadline, and they also are required to notify everybody, even if everybody knows it. This is what the law says you have to do. You got to notify the rest of the board that their failure to respond by that deadline will be the same as abstaining from the vote. And likewise, if anybody fails to require the vote to take place at a meeting, then the meeting's not going to be required, basically, that the vote's going to go forward. Now, that kind of clues you in on this other provision that's part of this law, and that is that any one board member can kind of torpedo the whole situation by saying, I want this vote to be taken at a meeting, not here at over email. But if you follow that process, people cast their vote, nobody kind of withdraws their vote before the deadline or changes their vote before the deadline, then the measure passes, as long as the same threshold that it would require for the measure to pass at the meeting. If you apply that same threshold to email, and that's authorized action that can be taken outside of a meeting by other means. Those are really, in my experience, kind of the biggest, hottest topics that face boards. And so with that, I'm going to turn the time back to Jeremy.